Good afternoon, everyone. We have already reached the appointed time, and we have already got a quorum, so let's get started. Item 1 on the agenda. Information papers issued since the last meeting. First, Administration's response to questions raised in the letter from Mr. James TO regarding the expenditure of discipline services on overseas duty visits, official entertainment and souvenirs that has been passed on to members. I'm sure you've all got it. Next, referral from the Public Complaints Office regarding separate confinement in Hong Kong, and we have been asked to see if we can take it up from the policy angle. And there is a letter dated June the 13th from Mr. James TO regarding the police handling of cases relating to political violence, and there's another joint letter dated June the 14th from Mr. Chen Kam-lam and Ms. Ann Chiang regarding the police handling of cases relating to child abuse. And just fresh from the oven, we have a letter from Mr. Raymond Wong concerning Oriental Daily Group, concerning fire services. So these are the papers that I have with me. So I suggest that we write to the relevant departments and bureaus asking for a response first, and if members want to take that up further, then we can include them on the list of outstanding items for discussion. Anything that you'd like to add? Yes, Mr. Dennis Kwok, Chairman. On repatriation, I'd like to ask some questions, not this one. Ms. Ann Chiang. Sorry, on the first item, with regard to torture claim and also refugee status application, I'd like to ask questions. Yes, you wait for your turn. Mr. Raymond Wong. Well, both myself and Mr. Kwok-him received a letter from Oriental Daily dated the 26th of June. And I've actually enclosed that to my letter to you. Well, on the 26th of June, the FSD received an anonymous email filing a complaint, and they actually went to the server room of Oriental Daily to check the automatic sprinkler system. And according to the letter from Oriental Daily, and also according to what we read from the news, well, nothing came about afterwards. So is the FSD really not having anything to do? Because for the server room, it's actually the top secret room in the news agency. So what you've done actually would give people an impression that you're actually creating white terror. So I think this is a very serious problem. What are you trying to do? So both Mr. Kwok-him and myself have written in, and we'd like the FSD to explain what actually happened on that day and how they would deal with such anonymous complaints. I can actually give you 1,000 such anonymous complaints if you want me to. So this is a news agency, and everybody is now scared out of their wits. So you will have to do something about it. Okay. So we'll pass it on to the relevant department. That's the concern raised by Mr. Raymond Wong, and we'll see what we will be doing upon receiving their reply. Yes, Mr. Chen Kam-lam, on the issue raised by Mr. Raymond Wong, actually I also submitted a question, and I also hope that the Secretary for Security can respond to that. Is that an oral question to be answered at the council meeting? Yes. I hope that they can give us a formal reply, because we're also very concerned about this, because upon the receipt of an anonymous complaint, and they try to enter the premises and conduct an investigation, but then for anonymous complaint, how should that be dealt with? So they try to kick up a fuss this time, and we think that that needs to be looked into. All right, let's see how they respond. Without further ado, let's move on to item 2, screening of non-refoulement claims. Paper number CB-2 1465-1. We have also invited the AJLS panel members to join us in the discussion on this item today. Let's first invite the Bureau Director to walk us through the paper. Yes, well, thank you, Chairman. In December last year and March this year, the CFA made rulings on judicial review involving similar cases, and the first one was the Ubermarker case in December last year. At the time, it involved a foreigner who had to be repatriated or expatriated from Hong Kong, and under Article or Section 11 of the Hong Kong POBO or PORO, yes, that might be in line with the basic law, but then under Article 3 of the BORO, well, with regard to individuals who might be subjected to torture or CIDTP, cruel, inhuman, or degrading treatment or punishment, according to the ruling by the CFA, is an absolute and non-derogable right, and therefore they should not be repatriated. And also under Article 3 of the BORO, there is a right on the individual to ask the HKSAR to examine whether or not the individual might be subjected to torture or CIDTP. And also another case is in March this year, and the 3 individuals in that case claimed that they would be subject to persecution upon return to their home country, and as a result they sought asylum from the UNHCR. One is from Congo, and 2 nationals are from Congo Republic, and it's found that for the overstayers, if they have to be repatriated or deported from Hong Kong, if it's found that they've already sought asylum, if they've already filed asylum claim with the UNHCR, then on humanitarian grounds, the determination by the UNHCR should be taken into account in determining whether or not the individual should be deported. And therefore, even if the Refugee Convention has never applied to Hong Kong, but then in considering whether or not the power to deport somebody is to be exercised, has to be considered. Independent consideration will have to be made in the light of the decision by the UNHCR, and we have been considering that in the light of BORO with regard to torture claim, and given the JR decisions by the CFA on the 2 cases mentioned above, other than the torture claim and also the risk of torture, we will also have to take into account whether or not between the time when the individual is to be sent to another country, whether or not there might be legitimate claims by that person because of participating in another social body, or because of other public opinion, and also because of his race, religion, nationality, membership of a particular social group, he might be subjected to persecution. And we have also taken into account the Court of First Instance requirement that, or the CFA's requirement that we will have to adopt high standards of fairness in considering any case. We will be asking the individual or the applicant to put in all the evidence and grounds, and also in the course of that, he'll be supported by publicly funded legal aid, and if he's aggrieved, he can also file an appeal, and the experienced judges and from the appeal board will be considering his case. And last year, with the amendment to the immigration ordinance, we have already turned that into a statutory mechanism, and the existing mechanism should be able to deal with such claims in a fair and independent manner. That's why, in accordance with the existing statutory standards and mechanism, we plan to introduce a unified screening mechanism, and that would also cover torture claim and also Referral Article 3, and also a claim for persecution. So the claimant will have to put in the grounds and also all the evidence and also supporting documents, so that the immigration department will be able to consider that in the light of the relevant factors, including torture, persecution, and other convention. And at the interview to be conducted by the immigration department, the claimant will have to furnish all the grounds and also the supporting documents and everything, and they are not supposed to furnish such information at different times. And under the unified mechanism, the claimant will continue to be supported by publicly funded legal aid or legal service, and barristers or solicitors who have undergone training will be providing free legal service, and that would cover the entire screening process, including helping the claimant to fill in the CAT claim form, accompanying claimant at screening interviews, examining the case, and assessing merits of appeal for claimants aggrieved by the decision of the immigration department, and representing claimants at oral hearing, if any, during appeals. And also, to prevent them from becoming destitute, we will continue to provide them with temporary accommodation, food, clothing, other basic necessities, appropriate transport allowances, and medical service during their stay. That's done on humanitarian grounds, and we have already made preparation for that, including approaching different parties, including the duty lawyer service and also the UNHCR, coordinating on the unified mechanism and also the appeal mechanism. And also, we will also arrange for appropriate training for torture claims, adjudicators, and we expect that once the details are finalized, the unified mechanism can come into play or can be implemented as soon as possible. That's the USM, the United Screening Mechanism. With us today for discussing this item, other than the Secretary for Security, we also have Mr. Wu Tek, Mr. Billy Wu, and also Mr. Fong Pak Ho. And before the meeting, we also received a letter from SOCO. We have already tabled that before members. And I can see that a number of hands have been raised. They'd like to join the discussion. Let me read out the names: Dennis Kwok, Ann Chiang, Raymond Wong, James To, Wong Kwok-him, and Chen Kam Lam, and Christopher, or rather, Chung Kwok Pen. All right, please make use of the 5 minutes given to you, and if you want the Secretary to give you a reply, please do make sure that you allow for enough time for him to answer. All right, I'll be grasping the time very tightly. Mr. Dennis Kwok, well, I have 3 points of concern. Number one is the transitional arrangement. Why did I say so? Because according to the administration, during the past 3 years, some 4,000 plus applications have been received. And if you set aside the 1,000 plus that have been withdrawn, there would still be about 3,000 such cases. So, in other words, the way that you've dealt with those cases, according to the Uramarka's case, you have dealt with that wrongly. So you're actually trying to adopt a consolidated approach in considering these three factors. So how about the 3,000 plus applications that you've already received during the past 3 years? I'd like to know how you're going to deal with that. This one first. Thank you. Well, for applications that we have not made a decision on, well, according to our current thinking, we will inform those who are processing the claims now, and also those who have yet to go through the screening interview. We'll inform them that we have got this new arrangement in place, and if the claimants themselves feel that there is a need for not just filing a torture claim, and if they want to put in the other two claims, then they can do so in writing, and all they need to do is to raise that with the Immigration Department.
When the new mechanism operates, the immigration will tie in with the new practice. The claimant at the interview can put forward more grounds and information for Immigration Department's reference to consider the three kinds of claims in one process. And of course, there three decisions will be made. If one claim is granted, the other two claims may not have to be processed. If the first claim is rejected, we have to look at the second and third claim. If the second claim is rejected, we have to look at the third claim application. If all claims applications are rejected, the claimant will be informed under the established mechanism. And under the established mechanism, the claimant can file an appeal. For CAT claims, there is legislation for that, and we have to follow the established legal procedures. For the other two kinds of claims, we go by of administrative means. Mr. Kwok, what about the claimants whose claim applications have been rejected? For example, Marca. Under Marca. So if the person is still in Hong Kong, he can file another claim. He can file a claim under Article 3 or a refugee claim. Let me talk more on the refugee claims. For some claimants, they are with the UNHCR and they're making further claims after their first claim is rejected. If the HCR confirms his refugee status, will follow the established procedures. If the claim is submitted individually, we have to look at C claim. According to the ruling of the C case, we have to refer to the information from UNHCR with the claimant's consent. For the duty lawyer scheme, the lawyers have to undergo new training so they know under the new laws there are new arrangements. The existing 4-day training is not enough to equip the lawyers. I think we have to review that. Just a brief answer, please, Mr. Wu. We have discussed this matter with the DLS. Sorry, what's that? We have started discussion on this with the DLS. I'm sure they will make appropriate arrangements. Dr. An Chang. Thank you, Chairman. We have to uphold international justice, but I'm a bit concerned. In Hong Kong, we have a large population but limited space. People like this stay in Hong Kong, cannot work, and then they just idle around. In Kowloon West, in Yo Chim Mong district, we have many of such people. I've received many complaints from Hong Kong people. I think we should let the administration know. Now, in the past, we only dealt with CAT claims. But now you're going to cover the other two claims too. I'm worried that more people will come to Hong Kong. So I have the following questions, Secretary. First of all, at present, for claimants of these three kinds, how many are we talking about? How many of them are in Hong Kong? And their average staying period. Third point, I want to know, for these people who are staying in Hong Kong, how much on maintenance and legal aid we spend on these people every year? May I defer to colleagues in Immigration Department to tell Dr. Chang about the figures. Dr. Chang, at present, we have 3,912 CAT claims still being processed. Rulings on case U and C by CFA states that under Article 3 of BOR, we have to make our own decision. But we haven't put in place the unified screening mechanism, so we know not the concrete specific information concerning BOR Article 3 claims and CAT claims. If we receive all information related and the forms related, we need 1 to 2 months to process such an application. Secretary, about expenses. In 2013-14, major estimates on legal aids amounts to $90 million. For humanitarian maintenance, $203 million. As for expenses on manpower, say for example, we need to engage DOJ colleagues to provide legal advice, and we have to engage immigration officers, and we also have to get people to provide clerical support to the appeal board. Estimates for 2013-14 stands at over $450 million. Ms. Chang. For the three counts of claims, CAT, BOR Article 3, refugee status, if we look at all three counts, do you expect a surge in number? It's hard to expect. For CAT claims, we have observed the trend. As for the refugee claims processed by UNHCR, we understand some cases are repetitive, they're duplicated. As far as I understand, there are 1,200 of such applications being processed by the HCR. As for CIDTP claims, we haven't started processing that, so I don't have figure on that. Next, Mr. Wong Yuk Man. Thank you, Chairman. For the unified screening mechanism, USM, for all kinds of claims application is for the administrative convenience and to cut down resources spent on that without affecting the claimants. On that basis, I would not oppose to the arrangement. I want to know whether persecution claims will be dealt with by UNHCR Hong Kong branch after the USM is in place, or will they be processed by Immigration Department of Hong Kong? For DLS, who are providing free legal services to the claimants, and they're paid out of public money. And the service will also cover claimants under BOR Article 3 claims. Before USM comes into operation, there should be necessary training to lawyers under DLS, but the administration says they are only discussing it. But at present, the duty lawyers know nothing about this. So you have to start the training immediately. And before the USM comes into operation, there are 3 points. The administration should look at the relationship between the 3 kinds of claims. You cannot separate the 3. That is CAT, BOR, and persecution claims. They are related. For CAT and BOR Article 3 claims, they are close in nature, but persecution claims is a bit different. For CAT and BOR claims, they are to prevent claimants from being subject to torture and CIDTP. For persecution claims is different. You have to consider whether it's a high risk or a genuine risk of claimants being subject to torture or CIDTP. And that because of his race, his nationality, religion, membership of a particular social group or political opinion in that country may be subject to persecution. These are matters you have to look at under persecution claims, so you have to provide training for the lawyers. The mechanism for persecution claims have been heavily slammed by the CFA. So before USM comes into place, you have to make appropriate arrangements with all relevant parties and to brief this panel on the details of it.
Secretary, well, thank you, Mr. Wong. I'll try to answer the question in 1 minute, 10 seconds. Well, you can also answer that when you answer other members' questions. With regard to asylum claim, well, the unified screening mechanism is still being studied. It has not come into play yet, and therefore, before that comes into place, that will still be processed by the UNHCR. But then when it comes into play, then the Immigration Department will be processing such claims in a unified manner. But of course, there will be transitional arrangements, and we are still working that out with the relevant parties. With regard to the second question by Mr. Wong, is about our lawyers under the DLS. They will have to receive immediate training. I agree that they will have to receive further training, and that's going to be done. But then what I'd like to point out here, as Mr. Wong rightly pointed out, with regard to the 3 claims, well, over a time, they are actually basing their claims on the same set of facts. And therefore, they try to make claims in 3 different areas, but then to a certain extent there would be duplication in the different areas. Well, there might also be some different circumstances, and therefore we will have to look at that as a whole. But then for what I have yet to answer in relation to Mr. Wong's question, I'll try to answer that later. Yes, James TO, and then Mr. Wong Kwok-him. Well, I'll be brief in my question, and I hope to get a brief answer from the administration. With regard to the unified screening mechanism, all right, with regard to the unified claims to be made by the claimant, do you intend to introduce a statutory mechanism to deal with all three claims, or is it that for the form it will be unified, but then for the procedures they will still be different? Because for the torture claim it's going to be statutory, but then for the other 2 claims they will remain administrative. Is that right? Well, after discussion, or for torture claim, yes, we will have to follow the statutory procedures, but then for the remaining 2, upon the we will deal with them under the administrative mechanism, and then we'll try to get more experience before taking the matter forward. And that's very similar to the way we dealt with the torture claim before the enactment of legislation. Well, I think it was the FB case, if I remember it correctly, and then on that particular case, we had to adopt high standards of fairness, and as a result of that, we introduced the brand new screening mechanism. We tried to do that by way of administrative measures, and then afterwards, we consider whether or not we need to amend the legislation and incorporate that as a statutory mechanism, and we will adopt the same approach in dealing with the other 2 claims, because we don't want to defer the implementation of that. But then I also have one worry, says Mr. TO. All right, for torture claim, it's a statutory procedure, and for the other, they are non-statutory. So have the DFJ told you? That is, if that's the case, then actually you will give rise to a new round of uncertainty. You will give rise to some uncertainty, because for torture you do have a statutory procedure, you have a timetable, it's rather tight. That's so much so that the side or the legal representative or the claimant will also agree that it's very strict and very tightly knit. And you said that under the unified mechanism there will be a joint interview, and all the grounds and evidence will be considered together. But then for the non-statutory procedures, if they have not been able to provide the relevant documentation and evidence, as you are not able to invoke certain provisions under the torture claim legislation, you cannot compel the claimant to furnish such information. You cannot just say that, all right, I'll be making a final decision with or without such evidence that you may or may not have. Then will that give rise to a new round of court cases, and as a result that might give rise to further uncertainties? Yes, I don't know how many cases you can process in the meantime, but then if you ask me, I'd rather that you have a policy decision and then you should turn them all into statutory procedures. I think that would be safer. Bureau Director, thank you very much, Mr. James TO, for your valuable comment. Well, according to our current thinking, for the other 2 claims, well, for the procedures, well, they will be very, very close to the statutory procedure, because the statutory procedure has given us a very solid foundation for dealing with such claims. But then Mr. TO said that if a particular claimant, after the interview, might need further time to get hold of further information, if that's the case, then the colleague responsible for the screening will have to make a reasonable decision that is in line with the decision by the court on the FB case. That is a high degree or high standard of fairness, and that will be the principle to be adopted. I don't quite understand. Why have you not decided to introduce a statutory procedure? Because you always learn from your mistake, and very nicely, you get a pay of hundreds of thousands of dollars every month, and every time you make a mistake, you said you would claim that you would learn from mistake. That's the case for legal aid and many other cases. Now I'm reminding you once again, you should have learn from the lesson from the torture claim situation, you should have made a policy decision right now, so much so that for the other two procedures, they should be made statutory. So can you cite two possible reasons why you'd rather not make it statutory now and prefer to have administrative procedure in place? Well, as we have said, in determining whether or not somebody should be deported, as the Director of Immigration will have this discretion, and he will have to take into account different factors, and according to the guideline by the court, we will have to adopt this high standard of fairness, and according to the high standards of fairness, that would be in line with the guidelines issued by the court. With regard to enacting legislation, we will have to accumulate some experience before we can do that, because before we make any further suggestions, if they have to be further amended, then that would be a waste of your time and efforts, and we cannot expect to have the cake and eat it. Mr. Dennis or Mr. Wong Kwok-him, well, for those who are facing torture or persecution, of course, we will have to consider their claims from a humanitarian angle. We should afford them with protection. But then according to the statistics, for those who are making such claims, and for those who manage to be screened in, well, actually the number would be very limited. And for the remaining ones, well, for those who are bound to fail, then they might have come here for other reasons, even for economic reasons, and they're trying to stay here. Well, because of the screening process that might take time, they might be stranded in Hong Kong, and according to some reports, that has given rise to a lot of problems. For example, illegal workers, and even law and order problems. That's why we are very concerned about how the administration deal with such torture claims, the timing that will be taken. So on average, how much time will be taken? For example, from the time they file such claims to the time after the screening is completed, whether they are screened in or screened out. So on average, how much time will be needed for screening such a case? We'd like to have some idea as to how much time that will take. And then after the screening, after the unified mechanism is introduced, do you expect that to be shortened somewhat? Well, on the time that will be needed, I'll defer to Mr. Fong to answer the question. Well, for the average time that is required, I'll try to answer that part first. Well, for individual cases, we'll try our best to deal with that, but then there are factors that are beyond our control. For example, under the existing torture claim legislation, we will give them 28 days. But then, as I can recall, when we scrutinized this bill, some members felt that 28 days would be too short, and they thought that a longer period would be necessary. And I can still recall that some concerned groups also said that 28 days might be a bit too short. But then, as Mr. Wong just said, the longer the time, actually the processing time would be even longer. And as a result, that might also give rise to other problems that will have to be dealt with. But then if you look at overseas experience in Canada, well, it used to be 28 days. Now it's been reduced to 15 days. And then in the UK, it used to be 10 days. And now, in some cases, they've actually managed to do so without giving any specific date. They would be dealt with right away. So for after the 28 day, if they can come up with some legitimate grounds, then we can extend the deadline. And then even after the first determination is made, well, there will still be this appeal mechanism. And under the appeal mechanism, yes, there is also a statutory time frame. I'm referring to torture claims. Well, in the light of the circumstances or merits of the case, they can come up with different grounds and so on. And our appeal board adjudicators would also have to look at the merits of the case, and therefore, cases might vary in terms of the timing that will be taken to deal with their cases. And even if you pass all those hurdles, well, there is still one final step, that is judicial review. And if they apply for judicial review, there would be further time given. Well, in some cases, they might be processed very quickly, but then in other cases, they might be dealt with rather in a very protracted manner. So for the details, I'll defer to Mr. Fong. But in fact, under the enhanced administrative mechanism in dealing with torture claims in the past, we have experienced some difficulties. For example, the claimant might not have attended the torture briefing in accordance with the procedure. We have not been able to process the claims, and also in some cases, the claimant might not have contacted the lawyer representing them, and as a result, the lawyer could not get the instructions, and they are not able to fill in the forms. And also, in some cases, for whatever reason, the claimant did not attend the interview, or in the process of the interview, they would claim that they are unwell, and then they would have to leave, and then afterwards they did not attend further interviews, or they have not been able to produce any medical certificate to prove that they were not feeling well at the time of the interview.
Some other claimants say that they would put forward more documents to support their claims, but when time's up for them, they haven't done so. We learn our experience from the statutory mechanism, and we believe that with the USM we can better deal with these situations. Mr. Chen Kam Lam and then Mr. Chong Kwok Ban. For the USM proposed by the administration, the processing will be streamlined. Looking at the figures, the countries these people are from are backwards and are small countries, and they may not have, and the rule of law may not be properly implemented there. What about people from democratic countries and where rule of law is well in place? For a claimant coming from such a country who says he would be subjected to unfair political treatment, persecution, or say a familiar example would be someone who says his country interferes with privacy and freedom. Would we try to verify his claims, and how will such a claim be dealt with? Secretary. Thank you, Mr. Chen. It's a very good question because this offers me a chance to give an explanation. No matter where the claimant is from, say for example, an underdeveloped country or countries of other kinds, the ruling on FB sets only one standard, that is high standard of fairness. I'm no legal expert, so I may not be exactly accurate, but to put it simply, we have to look at the claim and give the claimant sufficient chance to give his explanation and to put forward supporting documents. If the country of origin undergoes certain things or something happened in the country, as he claims, we will look at the relevant information. In the countries there are many reports of such claims in the by the NGOs. So there is bound to be lots of information with the NGO and with the country he's from. Let's call this information background information. We have to look at the background information, but we do not write a letter concerning an individual case. Say, for example, write a letter to a government asking him to give explanation on allegations. We don't do that. We only look at information on individual case and we strike a balance on relevant factors. We do that under USM. And the existing mechanism of CAT claims already covers that. When the case goes to the adjudication board, the board will also look at the information I've just mentioned. If the information is not looked at the appeal, it would be unjust. And in such a case, the court will not rule in favor of the administration. So no matter where the claimant is from, we adopt the same standard. We don't do double standard. As to whether a case is simple or complicated, it depends on the information, background information. Mr. Chung, my question is on CAT claims. If the claim is accepted, of course, the claimant will not be deported to the country of origin. But how can we facilitate the process of sending this person to a third country? So is it the case that if a country is willing to take him up, the person will be sent to that country? And what about the criteria of a third country taking in such a claimant? Thank you, Mr. Chung. For the three claims, if any one of them is accepted, the administration, of course, cannot send this person to the country where it's established there is persecution or where he is seeking asylum from. But we'll make arrangements for him to be sent to another country and out of Hong Kong. Before we do that, the third country will have to agree that it is willing to take up the person. And in that case, the claimant will be sent to that country. But in many cases, the claimant may not find a country that can take him in. So he is stranded in Hong Kong. And after a certain period of time is passed, we have to review the claim. If it's found that situation in the country of origin has improved, say, for example, the claimant is from country A where there are internal chaos, and so the claimant cannot go back. But after a certain period of time, situation changed in the country, then we can send the claimant back to the country of origin. This is the arrangement we go by. Mr. Chung, is it the case that for most of the claimants, they can't find a third country to take them in? Secretary, it's hard for the claimant to identify one, even if their refugee status is confirmed by the HCR. Even under the circumstances, it's difficult for the claimant to find a third country to take him in. Dr. Priscilla Leung and Mr. Yu Si-wing. Thank you, Chairman. After the Snowden incident, now of course he has left now, and our hot potato has left us. Well, he chose to make revelations in Hong Kong. And so Hong Kong people know without our consent, U.S. subjects us to surveillance. Much private data information have been tapped into. Well, I think his revelations are good to Hong Kong. We understand his acts. Now the U.S. considers he leaks national secrets and that he is accused of being an espionage. But what we have signed the MLA with the U.S. Mr. Kwok, was it? All right, please let me do it. I try to be tolerate, so members can express themselves. But please focus on the topic. Ms. Leung, Chairman, I think this point is important. Now my question to the administration is, how do they classify, or what do you consider as political offense? Do you consider it under CAT claims in the past? Are there any people who have committed political crimes and whose claims have been dealt with? What about the Snowden case? Is it a kind of political offense? Do you consider it as a kind of political offense? So you should not just go by the legislation on claims in hand. I think Ms. Leung, Ms. Priscilla Leung's question is not directly related to our topic today. We can discuss it on other occasions. For Mr. Snowden's case, the Secretary for Justice and other colleagues have made it clear that Mr. Snowden left Hong Kong in accordance with law. His act was lawful in leaving Hong Kong. It's an academic issue. But I would like to take this opportunity to say the following. For someone coming to Hong Kong, making a claim asking us not to deport him, and we have signed agreements to extradite a fugitive with the country he is from. If someone has to be deported from Hong Kong under the surrender of fugitive ordinance, and before he is sent back, he has filed CAT complaints, then the extradition will be suspended. The surrender will be suspended. I'm making use of CAT claims as an example because that's what we're talking about today. All right, until the time the CAT claim has been processed and completed, it's only by then that we'll deal with the surrender. I hope with this example, I offer an explanation to Dr. Leung on the spirit of law in an indirect manner. Chairman, I want to follow up. I think my point is related. It has to be established that the person, if sent back, will be subject to torture. Well, for political offenses, did you not consider this perspective? Are there any precedents? These are two different matters, two separate matters. For the surrender of fugitive, there is a classification criteria as to who can be surrendered, who not. But when we are considering this and the person has made a torture claim, then we have to deal with the torture claim. Depending on the outcome of the claim and the appeal, then we'll go back to see how the extradition should be dealt with. Mr. Yu Si-wing and then Ms. Emily Lau. In 2010, from 2010 to 2012, we see a decrease of CAT claims. 2010, 1,800, and then 1,420, and in 2012, 1,100. Number of deportation on the rise, 56 in 2010, and then 426 in 2011, and 2012, 677. How come one is on the rise, the other is falling? The 3 years between 2010 and 12, did you adopt the same standard in deportation and did you follow the same process? Mr. Fong. The Immigration Department act in accordance with law and our established practice. All along, repatriation, in terms of repatriation, these haven't changed. Even before the repatriation, we'll ask the claimant if he would like to raise objection to our decision on his torture claim, and if so, we will delay the repatriation. Under torture claims withdrawn has a large number, and some people were repatriated voluntarily, so they left Hong Kong voluntarily and returned to their place of origin. Number of withdrawal of applications amount to 3,500 plus. So the claimants withdrew the application themselves, and then we made arrangement for them to be repatriated. Mr. Yu, did UNHCR offer any help in terms of repatriation, and was the assistance sufficient? And did Hong Kong government pay for that? Let me supplement before my colleagues answer members' question. For withdrawn claims, there is a rise. I want to talk about the situation, but I'm not making any comments or putting forward any opinions. When the number peaked, the administration amended the law for people who are allowed to stay in Hong Kong pending the decision, and when they are found to be at work, they're committing a crime. After that, the number of claims have been falling. And after we have consolidated the statutory mechanism, we see similar situations, a similar trend. That is, the claimant came up and asked to withdraw the claim. So we see a rise of such figures. Mr. Fong.
In the past, when we worked with the UNHCR, while they sought asylum from the UNHCR, those cases would be scrutinized or screened by the UNHCR. And after the UNHCR has received such a claim, then they would notify the Immigration Department, and our long-standing policy is that we will suspend or withhold the repatriation pending a decision by the UNHCR. And once the UNHCR has confirmed his refugee status, then the UNHCR would arrange for them to resettle in a third country. But then before that is done, the Immigration Department would also be withholding the repatriation of such individuals until such time when they are resettled in a third country. Yes, Mr. Yu, I'd like to follow up on the issue of undertaking illegal jobs. That is, some people might have abused the situation and they're trying to come to Hong Kong to work, but then as the HKSAR government would allow them to stay, and as a result, more people would undertake illegal jobs. But then you said that many of them would withdraw their application after the statutory procedure has been in place. But then how many people have taken up such jobs illegally in the past few years, and have you taken follow-up measures to prevent this from happening again? And how are you going to prevent further abuse? Well, you've already overrun on your time. I'm afraid the administration cannot answer your question for the time being. Ms. Emily Lau. Yes, Chairman, I'd like to put this to the Secretary. All right, the CFA has made this ruling and judgment, and recently many law students have also approached me. Many of them feel very excited about this. Does that mean that the SAR government will be acceding to the asylum or the refugee convention? And apparently you said that your foreign policy will not be affected, but then the administration would not just accept the determination by the UNHCR, and you will have to conduct your own assessment. But then, as we have said in the past, well, why don't you just accede to the convention so that you'll be able to do both at the same time? But then you said that on this occasion you do not need legislation for that, but then you need statutory or legal backup for torture claims. So for lawyers and also law students, they're actually tuning in to listen to what you're going to say. So what is going to happen? Do you have to wait for a case to go to the CFA before a decision will be taken? Can you be brief in your reply? Well, in C's case, the CFA has already made it very clear as to what should be done, and therefore we will have to follow the judgment by the CFA and also our established mechanism and our policy. Well, the UNHCR, or rather, the Refugee Convention has never applied to Hong Kong. We've repeatedly explained that given the scarcity of land and dense population in Hong Kong, we are in no way to deal with that in accordance with that convention. But then how are you going to resolve the problem? Please do not just go back on history with us. Well, I was here. Can you, I'd like to clarify that. Well, for torture claim, after the administrative mechanism has been in place, after a certain time, we believe that it's time for us to legislate. That's why we introduced the legislation, and that was also enacted by this council. And the CFA's ruling was very clear. That's in the light of the fact that the Director of Immigration, in extraditing or in deporting somebody from Hong Kong, he has a discretionary power, and therefore, before somebody is deported, if he makes this claim, then we cannot just unilaterally rely on the UNHCR's determination as the basis for deciding whether or not a claimant should be deported or not, and therefore we will have to conduct our own assessment, and according to the CFA's guideline, we will have to adopt the high standards of fairness approach. And in the past, after the UNHCR has granted refugee status, then we will have to respect their decision, and we will allow them to stay. And then we will wait till a third country has decided to resettle him. And even if that is not granted, then we will have to respect that decision. We will have to deport him. But then according to the CFA, that cannot be done. And if you want to send him away, then you will have to conduct your own assessment. That's why under the proposed mechanism, we will do exactly that. We will do our own assessment in accordance with the high standards of fairness. We will have to determine ourselves whether we will be deporting that person from Hong Kong. So that's the decision by the court, and of course we will have to follow the decision by the CFA. Ms. Lau, all right, you're actually doing this time and again, and then when the court says that it's not working, then you will have to legislate. Is that right? Well, we follow the decision by the court, and according to the guidelines given to us by the court, we will strictly abide by that. And of course, in court cases, even if the law is in place, there are bound to be court cases. So I think that's another story. But then for torture claim, for the legislation, of course, that has given rise to a lot of court cases. But then there is a convention to go by. And of course, you've also acceded to that convention. But then in this case, you've refused to accede to that convention. But then if the CFA says that you will have to legislate, but then if you have not acceded to the convention yet, then what is going to happen? All right, the UN has asked you to accede to that convention many times. So can it be a case that we will legislate, but then we would not be acceding to that convention? Whether or not the convention should apply to Hong Kong, our view has never changed. And if the court thinks that we should do this, then we will act accordingly. And I believe that there is a way for us to get around this without acceding to the convention. So it's like the torture convention. Is that right? Would that be strange, Secretary? Mr. Lam Tai Fai, and then Tony, and then Paul Chair. Thank you, Chairman. Just now, the Bureau Director said very modestly that he's no legal expert, and of course, I'm a layman to law. But then when this happens, well, even if it's been dealt with, it doesn't mean that it's not going to happen again. As Priscilla Leung just said, she referred to the Snowden case. Yes, Snowden has left, but then there are still some consequences. So there is no guarantee that there will be no repeat of history, and that individual might not have come from the U.S. He might have come from Russia or another third country, even North Korea. All right, the administration has repeatedly emphasized that it's not going to comment on this case, but then I'm sure the administration must have got hold of some insider information and some insider news, and of course we might not be aware of that. Well, Priscilla Leung said that well, you should have known a lot, but then I think you're actually gagged because you're not able to disclose everything. But then assuming that Snowden is still in Hong Kong, then will he be qualified to apply for this non-refoulement? So that's my first question. And just now I've also checked this out with Dennis Kwok, who's a lawyer. All right, for such claimant, they should not be allowed to get jobs or find jobs here in Hong Kong. But then apparently I've been told that they'll be paid $12 a day if they stay and work in Hong Kong. But then how are they going to sustain themselves while they are staying in Hong Kong? And Hong Kong will also have to protect them. But then on the other hand, they are not allowed to work. But then they might resort to criminal or committing offenses in Hong Kong because they are not allowed to work. And well, there's an Indian who actually raped a university student from from Peking University the other day at Chongqing Mansion. So they are not competitive. They are not able to integrate into society. So it's like a bomb in Hong Kong. On the one hand, we have to protect them, but then on the other, we are actually like protecting a bomb. So that's not going to work. So in the screening process, when we try to identify a third country for them to go to for repatriation or whatever, so how are we going to make sure that that bomb will not explode in Hong Kong? Well, I'll try to answer the first question, and then for the remaining ones, I'll ask my colleague to answer. Well, for any foreigner, and of course, I don't intend to discuss the issue of Mr. Snowden here. All right, whether he's an individual from a particular country, so long as he's a foreigner, an expat in Hong Kong, and if he breaks the laws in Hong Kong, for example, if he has overstayed, then he will have to leave. And if we have to repatriate him to a third country, and if he makes a torture claim, or if he makes a claim under Bill Rule 3 or a refugee claim, then we will have to act in accordance with the established criteria. And even for torture claims, well, if he has not overstayed, then we will not be dealing with his cases, because the triggering event would be he will have to breach his conditions of stay. He must not overstay in Hong Kong. And if he has overstayed, then we will of course have to deport him. But then for the relevant legislation in place, it says that we will first have to process his claim before he can be repatriated. And only when that is triggered before will we be processing such cases? And then I'll defer to my colleague with regard to how they can sustain themselves, whether or not they'll be supported while they are staying in Hong Kong. All right, can you speak to the microphone? Sorry. All right, the claimant is not allowed to work in Hong Kong because they are regarded as overstayers or illegal immigrants, and on humanitarian grounds during the stay in Hong Kong, if they have actual needs, we don't want them to become destitute. The SWD, in collaboration with a non-governmental organization or an NGO, has come up with a plan so that during their stay, some in-kind humanitarian assistance will be offered to them. And as mentioned by the Secretary, that would include their accommodation, food, clothing, and other basic necessities, and appropriate transport allowances, so that even if they are not allowed to work in Hong Kong, they would not become destitute during their stay in Hong Kong. So the SWD, together, when it came up with this plan, that's the purpose. So how much will be offered to them?
I don't have the information at hand. $12 a day? I really can't tell at present, but the organization and the SWD will review the actual needs at a regular basis.
Well, according to the UNHCR, actually, they are actually hosting the fees while Hong Kong has to foot the bill. In fact, they still owe us a lot of money without repaying us. And of course, we try to be as humanitarian as possible, given the fact that Hong Kong is an affluent society. But then there is a limit as to how far we should go. But then, while Hong Kong has already taken up the burden, and yet many of these claimants are not happy, because on the face of it, you might claim that you have been very humanitarian, but then given the protracted processing time, they are actually living in difficulty, and they are actually having a hard time here. So can we look at it more pragmatically? For example, in Singapore, of course, we might not be very happy with Singapore when it comes to their human rights records, but then they have been very pragmatic. In particular, they've also got a lot of experience in dealing with South Asian refugees. So in the past, the success rate has been so low when compared to Australia, it's 44%, but then in Hong Kong it's only 0.1%. So given that situation, can we be more pragmatic and realistic in looking at such claims? Instead of spending so much money to support these people who are pending screening, can we be more proactive in conducting such investigations instead of relying on information online and also correspondence with relevant institutions and so on? Well, can we send somebody to these countries to conduct more on-the-ground investigations and comprehensive investigations so that we'll be able to apply this to some people from a certain background instead of spending money on individual cases, because it's a waste of time and money? Secondly, well, whatever you call it, well, for people who are trying to abuse the situation, if they're trying to make money while they are here by engaging in illegal work, some would be selling fake or counterfeit goods, as Mr. Lam Tai Fai put it, and they might actually be engaged in terrorist crimes. So in order to avoid this from happening, so can we distinguish those genuine cases and those false cases? So can we allow them to work on certain conditions, and for those who have accepted such conditions within a particular time frame, they would not be eligible for making such claims, and they will have to leave. So for genuine refugees, of course, they will not accept that. But then for others, well, they'll be happy so long as they can work for 2 or 3 years. Would that be good for Hong Kong in the long run? Number 3. Well, that might not be an entirely right analogy. I'm not saying that they are useless. But then at the immigration or at the point of entry, should we be more stringent? Because there might be situations involving these people. So in terms of the entry visa, can we make it more stringent? So that for visitors who are genuine visitors, they would not be affected, because well, after they've come in, and if well, for genuine refugees it's okay, but then for those who are not genuine refugees, some would just come in to work illegally, and some who might have been screened out would also be very disappointed. Thank you for your valuable comments. All right, on proactive investigation.
Now, for information in relevant countries, we get the information is processed by designated officers. For example, officers in UNHCR or international rescue institutions, or we're talking about some reports by internationally reputed organizations. And we look at such information, such reports, and we have to spare effort into collecting such information, but it doesn't mean that we spend lots of time in doing so. The claimant has the responsibility to put forward substantial grounds. It's not like he gives us an oral claim and then we do all the work. This doesn't fit into the high standards of fairness. We have to get information available. That's the guidelines from the court. And next point, to allow the claimant to work for 3 years, and after that he has to go back. From the perspective of entry and departure, is not feasible, because otherwise anyone can come to Hong Kong and work for 3 years. Management at the point of entry. The claimants are categorized into 2 groups. One group are those entering Hong Kong unlawfully. We have visa control, but it doesn't mean that one can enter Hong Kong with traveling documents. And another group are overstayers of domestic helper, foreign domestic helpers. And they may not be able to find work after their contract expires. And they are not directly related to the safety claims. Mr. Leung, speakers off mic. For asylum claim, the HCR determines on the case first, and then the immigration department makes your determination. So what if the HCR determines the grants the claim, and it doesn't mean that you will necessarily follow the HCR decision. If the claim is justified by the HCR, we respect the decision of the HCR. Will exercise discretion and allow the claimant to stay in Hong Kong temporarily until he is arranged to be sent to a third country by the HCR. For those whose claims are rejected, according to the court, we have to make our own assessment before sending the claimants back. All right, understand. I want to ask questions about Snowden. He is not a refugee. He never claims to be a refugee, right? Yes, continue, please. I'm asking if it's right that he never claims to be a refugee. Secretary, I will not comment on the Snowden case anymore. He's not in Hong Kong anymore. The Secretary gave an explanation earlier on. After the visa expires, the situation may be the answer to your question. And his visa has not expired. He can put up a defense. He doesn't have to make asylum claim. So in that case, the asylum claim will not be effective. You have to make it clear, because Hong Kong people do not know about it. So Snowden can always oppose the extradition. To exercise powers conferred under the extradition ordinance, the In doing so, the person involved can put about defense or put forward objections. So CY Leung can make his own decision. If CY Leung thinks the extradition is not reasonable, he can always say no, right? It's not necessarily as complicated as members mentioned, right? For all relevant ordinance, extradition, SFO, it states clearly how we deal with individual cases. That is, we have to act in accordance with the law. You are representing the CE. The CE can make the decision, right? Say a government asks you to surrender someone. In fact, the CE can say it's a matter of politics, or the person is a political criminal. The person will not be surrendered. I wrote a letter on that, and yet you talk nonsense here. I don't think I'm talking nonsense. I'm simply saying that we have to act in accordance with the law and what says under the law. As for individual cases, we don't openly discuss them. So, Snowden is not here to seek political asylum. Do you think this is a fair statement? Any reply from you, Secretary? I won't make any comment. What? I'm asking you something like, does the sun rise from the east? Well, it's not as simple, Mr. Leung. Snowden never filed any political asylum claim. He can always put about defense if he's asked to be surrendered. He did not have to make any claims. I think the Secretary has already given you a reply, and he said on certain points he will not make any reply. But people have a discerning eye, but don't talk nonsense. Mr. Tan. BOR Article 3 says that people should not be subject to torture or CIDTP. Is death penalty a kind of torture? Is it something cruel? For a criminal who faces death penalty in his place of origin, if this is a claimant, will he not be surrendered? If the country of origin undertakes that the person will not be sentenced to death penalty and asks for the person to be surrendered, will the person involved be surrendered? As far as I understand, for agreements on surrender... sorry, I cannot hear you, Secretary. Is it better now? Is it better now? Sorry. Let me repeat. As far as I understand, we have signed some agreements on cooperation and extradition, like MLA. There are some offenses stated there, and the offenses do not warrant death penalty. And if the maximum penalty of the offenses involved can be death penalty, we will ask for a guarantee and assurance from the country to ensure that the person, after he is sent back, will not be sentenced to death penalty. Follow up? Well, if without the agreement and there is evidence showing that the person after being sent back will be sentenced to death penalty, how will he be dealt with? If there's no such agreement, there's no question of sending him back. Without the MLA, there's no question of sending him back. Well, under BOR 03, the claimant has to put forward his grounds for the claim. And the court already set down some criteria. Well, the criteria is not that easy to understand. So first of all, the claimant has to show that he faces a genuine and substantial risk of being subjected to torture or CIDTP, which has attained a minimum level of severity, no matter how objectionable his conduct or character may be. And the hurdle, the threshold, is very high. And if I remember correctly, we have to look at the facts of the case, of the claim, before we look at the criteria I've just mentioned and make a decision. So we cannot simply rely on the claimant and take his words. So without the MLA, and the person overstays and he claims that after being sent back, he would face the relevant sentence, what will happen? As I understand, the precedents is not related to what Mr. Tan has said for the other cases outside Hong Kong. As far as I remember, the matters mentioned by Mr. Tan is not directly involved. First round, any further questions? If not, let's go into second round. We still have a number of items to be discussed. So I'll draw a line in the second round. Mr. Dennis Kwok, James To, Priscilla Leung, and Paul She. Anyone else? All right, I'll draw a line here, 2 minutes each. Please be brief. If you want the Secretary to answer your question, please leave more time for him to do so. Mr. Dennis Kwok. Chairman, many community organizations are concerned about it. I was up in the public gallery. Lots of NGO representatives are here. They are really the frontline workers in dealing with refugee claims or such claims. So I would like to ask the chairman to set down a public hearing to listen to the NGO's views. They are more familiar with such matters than LegCo members here. Next, point 2 in the letter from SOCO is the point mentioned by Ms. Lau and Mr. James To. So this letter actually addressed this point about legal basis. Third point about humanitarian support. I don't know if the Secretary had a chance to take a look at the living environment of the refugees. If not, I'm very happy to go with you, Secretary. As far as I know, in terms of food, one claimant gets a subsidy of $12 per day and they can't take up any work. Some religious groups would like to ask them to help at churches. But still, the claimants can't take up such work because they are worried they may breach the immigration ordinance. So, Secretary, will you consider making arrangements for them? They may not be able to take up work. They can't be allowed to take up work. But will you make arrangements for them so that they get occupied and they will not be negative elements in our society?
With regard to the humanitarian assistance, I don't have the figures with me, but I believe that for the $12 per day might not be entirely accurate because if you're talking about $360 a month, then as far as I am aware, the amount that is given should be in excess of $1,000, and therefore I don't think the $12 per day rate is accurate. Mr. James To, I'd like to ask this according to your initial analysis. Well, other than the torture claim legislation for the making the other two screening processes statutory. What's the problem with that? Well, as we have said in the past, we did have a lot of experience, and the court has also looked at the administrative measures that we put in place in the past, and the rationale behind that. The court thought that there was some inadequacies. That's why, step by step, we came to have this mechanism in place today, and that's why for the other two claims, we believe that is better safe than sorry. We should adopt a prudent approach by doing this. We are not ruling out legislation. Well, you've already accumulated a lot of experience. There are also a lot of overseas experiences. So why can you tell us what might be the merits of introducing legislation for the other two claims? Well, for example, for BOR Rule 3, with regard to inhuman treatment, or CIDTP, all right, they are not like torture claims or asylum claims. We do not have very detailed and specific definition imposed by the court. We will have to look at them on a case-by-case basis, and therefore we will have to develop the experience. And I've also personally been to Europe to talk to some of the officials processing such claims, and the information that I gather was more or less the same as we knew. We would have to accumulate more cases before we would know what to do, or else if there is a further court case, then we might have to amend the legislation again. I think you're burying your head in the sand like an ostrich. Well, for such repatriation cases, in the end, it would also affect our foreign affairs and foreign relationship. And also, as you stated in the paper, some claimants might have some claims, and amongst the reasons, whether or not they have certain political opinions, or if they are members of certain social groups and so on. And in the end, it all boils down to whether or not they might be subjected to persecution. All right, if you have different political opinions. So I'd just like to know, in the past, have you dealt with cases involving any exceptions under the MLA agreement? In other words, there might have been political offenses. It might not have been asylum claims or refugee claims and so on. All right, in the press, you've disclosed this case involving a Libyan. All right, if he lost the case, would there be a chance for him to resort to another mechanism, saying that, well, in my case, this is an exception under the MLA agreement, and therefore, if I go back to the country, then I might be subjected to torture. So in the past, have you dealt with such cases? Well, Ms. Leung, you refer to para 11, and you're referring to this asylum claim that is under the 1951 Convention relating to the status of refugees. Well, because they are concerned that because of political opinions, race, religion, nationality, membership of a particular social group, this is about asylum claim. But then, as you are aware, this refugee convention is not applicable to Hong Kong. But then in the past, yes, all such claims would be processed by the UNHCR, and the administration up till this day has never processed such claims. Mr. Paul Chairman, I just gave some views, and apparently, well, you might think that they are outrageous, but then if you look at the current situation, given the fact that some of these cases have taken an unduly long time, and we have spent a lot of money and efforts, and it's like putting up a show. So we should review our situation. We have already reached a stage whereby the situation is already out of control, and therefore we should come up with we should think out of the box. And even for countries that claim to be very humanitarian, they have also come up with some innovative ways of dealing with them. And actually, some might have applied for a work visa before they come to Hong Kong, and you know what they are actually for. But then how come just because of the halo effect, we try to do such unnecessary things. I hope that you can review the situation. I think the situation warrants this approach because the situation is running out of control, and therefore we have to think out of the box in dealing with such cases. Bureau Director, thank you, Mr. Chair, for your valuable comment. I believe that what we are discussing today is we all agree that under the current legal framework of Hong Kong, we need to do this, and Hong Kong is a city espousing the rule of law. We have to respect the rule of law, and of course, Mr. Paul Chair said that some claimants might be abusing the mechanism, and I personally think that, well, in other places that would also happen, and when such cases arise, we will have to look at them on a case-by-case basis as to what approach should be adopted. Well, in some countries, all right, in one country, they would just do away with the number of days that would be allowed for him to fill in the form. So they would just resort to immediate decision or determination. Yes, Yu Xi-wing just raised his hand and he'd like to have a second round, but then sorry, I've already drawn the line. All right, I think today's discussion has allowed many members to express their views on this, and I'm sure the administration has taken on board the comments, and Mr. Dennis Kwok also said that some NGOs or voluntary agencies who are working at the front line would also have a lot of comments to make, and he asked if we can hold a public hearing on that. Well, I'll ask the Secretariat to send out an invitation online so that for groups or deputations who would like to express their views, they will indicate first, and then we'll make a decision on whether or not we're going to hold a public hearing on the issue. All right. So much for this item. Of course, you can ask people to send in their submissions, but still, it's better to have a public hearing, because I don't want to ask how many deputations or submissions do we have to receive before you would decide to arrange for a public hearing. I'll try my best. All right. Item 3 on the agenda: review of the Interception of Communications and Surveillance Ordinance, or the ICSO. With us today include Secretary for Security, Mr. Lai Tong Kwok, and Mr. Wong Pik San, Superintendent, and Mr. Yu Wai Keung, and Ms. Carol Yip. How come I couldn't find your name here? So Ms. Janet Ong is also here with us on this item. Yes, Bureau Director. First of all, on the review of the legislation, we have already submitted a paper to members setting out some of the legislative proposals that we have for the ICSO. Well, under the law, well, that is to ensure that we will have the capability to combat serious crime and protect public safety, so that the law enforcement agencies are able to undertake covert surveillance, and that is also to ensure that we'll be able to protect public safety and combat serious crime. And at the same time, we also have to protect the public's privacy rights. And the former commissioner, in discharging his duties, put forth a number of legislative proposals so as to enhance the functioning of the law. As for those who do not require legislative amendments, we have already amended our code of practice in the first place, and for others that would require legislative proposals, we have already conducted in-depth review of the legislation. Well, the former commissioner was most concerned about the power to examine and listen to products of covert surveillance. As members are aware, as to whether or not the administration will be implementing the requirements or the proposal by the former commissioner, so that there would be specific provisions for the Commissioner and his staff to examine the products of surveillance. After very detailed study of the proposals by the former Commissioner, we have also conducted 2 rounds of consultation with the stakeholders and also at previous discussions of the security panel. What we are proposing now in terms of implementing the proposal by the Commissioner, so that there would be specific or express provisions for the Commissioner to intercept or to have access to protected products. Well, the Commissioner will be able to have access to such protected products, including the interception results and also LPP materials and also news materials. And the Commissioner would also be able to conduct random check on other cases. And after the amendment is enacted, we believe that would facilitate the Commissioner in discharging his statutory duties and functions. As I've said in the past at this panel, well, to allow more people to have access protected materials, and we will have to strike a balance between protecting privacy and also in facilitating the work of the Commissioner, and also in enabling the law enforcement agencies to go about their work. So we will have to strike a balance. And in the 2 rounds of consultation with the stakeholders, the stakeholders generally welcome the enhancement of the powers of the Commissioner, so that he will have access to protected materials or products of surveillance. And some suggested that safeguards would have to be put in place. For example, the Commissioner would only be allowed to conduct random checks, so that only a limited number of people will have access to such materials, and it has to be targeted. Only prescribed prescribed officials will have access to that, and we will continue to liaise closely with the Commissioner on such details of the administrative arrangements. We'll iron out the details later. But then, given the amendment, that would also cover the other areas. And in the comprehensive review, other than making specific or express provisions to authorize the Commissioner to have access to such protected materials, we will also have other measures to put in place the recommendations by the former Commissioner, and that is also on the basis of previous discussions at this panel, and they have also been supported by majority members of this panel. These include panel members and also authorized officials or officers between para 12 and 18 that has been spelled out, so that the existing panel would also have enhanced functions, so that after the termination report or REB 11 report is submitted, then the panel judges can comprehensively withdraw the authorization, or they can also alter the conditions that have been imposed. And also, secondly, there should also be appropriate interpretation of the relevant wording. That's in para 21. In other words, without specific authorization, and if an LEA intercepts or conducts covert surveillance, then the Commissioner can also inform the relevant parties, and the former Commissioner is of the view that the wording will have to be clarified, and therefore we will be amending the legislation so that the relevant wording will be clarified. And thirdly, time gap between the revocation of the prescribed authorization and the actual discontinuation or discontinuance of the operation, that's from 22 to 25 in the paper. That is for the the Commissioner raised concerns regarding technical unauthorized operations resulting from the time gap between the revocation of a prescribed authorization and the actual discontinuance of the operation, which are unavoidable. The former Commissioner proposed that this is, given the fact that this is inevitable, we will have to make sure that it's not unauthorized, so that such activity will not become unauthorized or irregularity. For the rest of our recommendations, they have been set out in detail in the paper, and therefore I do not propose to bother you with all the details here. So let me summarize it here. Well, in the light of the recommendations by the former Commissioner, we have already consulted the relevant stakeholders on the whole. They are of the view that with regard to the proposed amendments, they are supportive of them. And we have also taken the opportunity to talk to the panel judges and also the incumbent Commissioner. They have all accepted these recommendations. Thank you. All right, thank you, Secretary.
我哋出席嘅官員不過喺度就更正翻，包括
Let me repeat once again who are with us today. We have Ms. Carol Ip, Deputy Secretary for Security, Mrs. Millie Kong May, Principal Assistant Secretary for Security, Ms. Alice Young, Assistant Secretary for Security, and Mr. Godfrey Can, Senior Assistant Solicitor General from DOJ. Mr. James To, Emily Lau, Sid Ho, Alan Leung, Dennis Kwok, on the 17th of June, sent me a joint letter asking for discussion on the interception of communication, surveillance ordinance, personal safety, and relevant matters. And so I think the matters raised by them can be discussed under this review of the ICSO. This item, agenda item, was supposed to be for the next meeting, but just members put forward some joint requests. Mr. James To, Sid Ho, Mr. Tan, Sin Chung Kai, and Mr. Ronnie Tong has already been queuing up for questioning. Mr. James To, 5 minutes. Chairman, the topic is the review of ICSO. I think we should say the review in accordance or in the light of the ex-commissioner's suggestion. This is not a full review. The administration has not considered members' request to amend the ICSO. The amendments are only those recommended by the former commissioner, so the review is not comprehensive. Secondly, me and other members asked to have a review not just on this ordinance but others. We asked for a meeting specifically for the review of relevant ordinance. Now today we're going to discuss this ordinance, so I'm going to stick to it today. From the Snowden case and his revelations, provisions of ICSO or telecommunications ordinance do not give us power or extraterritorial rights. So for overseas contractors, companies, or individuals, companies with large resources, conduct hacking and tapping into communications overseas, there may be some loopholes, and we can't prosecute these people with existing ordinance. If we're talking about a superpower, it's no longer a question whether the country should be prosecuted. It may be involved in political disputes between different countries. Recently, we learned that even Germany and other countries, their system are hacked into by the US. So we have to have a more comprehensive ordinance. That's why I say we have to have extraterritorial rights. Margaret Ng and I, when we drafted the ordinance, we put forward over 100 of amendments, one of which is about setting it down that public officers without any warrants conduct such acts should be regarded as committing a criminal offense. But this has not been included in the review. This is a kind of shortcoming. Well, I think it's good that you put in place the proposed legislative proposals and amendments just to increase the deterrent effect. But still, I think the current review is not a comprehensive one, it's not a full one. So we need a full review, and I'll follow up on this matter, this review in this panel. So administration, can you give a reply to the extraterritorial rights? Thank you, Mr. To. Mr. To has been followed up on this matter from the very beginning up to this stage. I'm sure he's more familiar with this item than me. Extraterritorial rights for ICSO. Under the Basic Law, Hong Kong people enjoy freedom of communications. But the ICSO is about special circumstances so that LEAs can make use of certain means in combating serious crimes and protecting public security. And law enforcement agencies, LEAs, of Hong Kong cannot conduct their duties outside Hong Kong. I think Mr. To's question is about another matter. Last Wednesday at Council meeting, I gave a reply to an oral question already. As I understand, tomorrow there will be a similar question. So there will be further exchange between the administration and LegCo members. As for the criminal liability of public officer, apart from the penalty under administrative means, there are some circumstances where a public officer may be prosecuted under misconduct in public office. Mr. Ho, Chairman, the ordinance came into place in a rush after Mr. Leung Kwok-him judicial reviewed the administration. So the ordinance cannot protect privacy of Hong Kong people. The ordinance gives power to LEAs locally, but for overseas LEAs or non-LEAs locally, if they tap into communications, privacy of Hong Kong people is not protected. If members of the public suspect his communications is tapped into, they can only make inquiries with the commissioner, and the commissioner will give a written reply to see if the communications have been tapped into or not. It's not sufficient to protect privacy. So you have to extend the scope of the ordinance in order to protect freedom of communications of Hong Kong people. So it's not just about setting boundaries for interception of communications and surveillance. These proposed amendments are suggested by Mr. Hu, Justice Hu. But the suggestions are not sufficient. Well, there's one good point, because the commissioner can check the protected products. But this is just a small step. The administration has already conducted consultations may I suggest we hold a public hearing? That should be before the Blue Bill. We should hear public view at this stage. According to the paper, the administration consulted the law faculties of universities, people in the media, professional groups, panel judges, and a former commissioner. What about telecommunications companies and some concerned groups? Have you asked these people what their views are in terms of interception and covert surveillance? Can these companies, telecommunications companies, operate independently without fearing the administration so that they do not have to reveal privacy of their users? It says in the paper that panel judges and former commissioner will be consulted. How come they are not consulting? They will not continue to consult the media and the human rights groups, and have the groups' points been incorporated? We don't know. Freedom of communications is very important to journalists because it hinges on the independence of the media and the freedom of reporting. So, Chairman, before we end this meeting, we have to set down a date for a public hearing to listen to deputations. Secretary. Chairman, I have to stress that we are very stringent in terms of monitoring the LEAs under the ordinance. Now, the ordinance itself is very thick. And the ex-commissioner reviewed the ordinance very carefully, and his annual report are very detailed, and he pointed out that there should be administrative amendments, and in some areas there should be some legislative amendments. For example, whether the commissioner should be allowed to make assessment vetting. As I said, consultation is a separate matter. After the consultation, we'll talk to the panel judges and the members. This is an important step to improve the ordinance, and that's our focus. Freedom of reporting is something we value very much. In previous reports, ex-commissioner put forward some views on that. And the incumbent commissioner, I'm sure, will continue this practice. We continue to enforce the ordinance and ensure the LEAs will act in accordance with the law. Well, Ms. Ho, I'll handle your request later. I am afraid I have to leave. This item was supposed to end at 4:05, so Chairman, please address my request later. Mr. Tian. A simple question. Para 11 says that the administration will work out the administrative arrangements with the Commissioner on necessary safeguards such as the selection of protected products for checking, etc., to assist the Commissioner to perform such duty, supervision, and security measures.
I'd like to know if the Commissioner will be designating a certain number of staff to listen to such protected products, we will have to be very careful at what rank are they going to be. And if there are so many people and if you have no idea as to what ranking they belong to, then it might be kind of risky. So where would you draw the line? What's the number and also the ranking of staff to assist the Commissioner in performing this duty? Yes, as the Honourable Member rightly pointed out, on previous occasions when we discussed this issue, members have also expressed a lot of views, and we fully understand that if we do authorize the Commissioner to double-check the protected materials, then the powers would be very extensive, and therefore the smaller the number, the better. On the other hand, we also fully appreciate the fact that the former Commissioner was making this request, and he felt that there was this need, and therefore between the two we have to strike a balance. That's why what we are proposing now is to give this express authorization. But then Mr. Tian was asking how many people will be authorized and at what rank are they going to be. Well, for such details, we will have to sort that out with the Commissioner, so that we can reach a consensus on the arrangements. And then after this consensus has been reached, then administrative arrangements will be put in place. But then in reply to Mr. Tian's question, all I can say is those of us in the Bureau and also the Law Enforcement Agency and also in the Office of the Commissioner, we all understand that when we access such materials, we have to work in accordance with a very detailed code, and measures will also have to be put in place so that the public will understand that our actions would be reasonable, legitimate, and is also proportionate to the needs of our work. And in the course of working out the administrative arrangements with the Commissioner, Mr. Tian's concerns will be fully reflected to the Commissioner, so that he'll be invited to take on board those concerns. But then in terms of the ranking of the staff, what mechanism would be adopted? So above a certain rank, they will be allowed to have access. So what rank do you have in mind? Alright, the Secretariat has already got some very senior staff to assist the Commissioner in performing his day-to-day duties, and of course, in the course of doing that, they would also assist the Commissioner in checking certain files and documents, because the Commissioner cannot just perform his duties on his own or alone, and therefore there are already very senior ranking officials or officers assisting the Commissioner. But after sorting out the details with the Commissioner, we will be able to tell you more about that. But then before that is done, I'm not able to tell you exactly what ranking these officials or officers are going to be. But then all I can say is they should be sufficiently high-ranking officials or officers before they will be assigned to assist the Commissioner in performing such duties. Next, Mr. Sin Chung Kai, and then Mr. Ronnie Tong. Chairman, I'm not familiar with this piece of legislation, but then I've also read the background paper prepared by the Secretariat and also the administration's paper. I've got this very fundamental question. Alright, since Snowden's saga, after the disclosure has been made about NSA's hacking or covert surveillance on overseas governments or institutions and also their nationals, and also even within their homeland, for non-Americans or non-American citizens, they've also been hacked. Alright, well, we have been shocked by such indiscriminate hacking and tapping. They've also got foreign intelligence surveillance court. I don't know what the Chinese name is. So it's a court to hear cases involving overseas surveillance. Alright, even for the NSA in the US, they will also have to go to this court to seek a specific authorization before they can undertake such activities. And of course, in the Snowden's case, some 90+ 90+% of the case or times they would get approval from the court. All right, that could be criticized, and still they have this court in place. And yet in Hong Kong, we don't even have this court. We don't even have a specific court to deal with such cases. So at least we should align ourselves with a country that we are criticizing so severely. Yes, I agree with your criticism with regard to the U.S. surveillance program. But then have we ever thought about this? Can we set up a court specifically to deal with such cases? Have we ever thought about this? Bureau Director, I'll say a few words on that, and then I'll defer to Ms. Yip, who will give you more details. Well, at present, under the ICSO, there are two types of surveillance, or two types of cases. One would be more intrusive, and in those cases, they will have to apply for approval from the panel judges. All right, we have a commissioner who is an incumbent judge. All right, he'll be responsible to oversee the law enforcement agencies to see if they're acting in compliance with the statutory requirements. That's one side of it. On the other side, well, where the law permits them to do certain things, and if LEAs were to take certain actions, then they will have to get authorization from the panel judge. In other words, they will have to come up with an affirmation, and then they will have to submit it to the panel judge, and then the panel judge will do a take there, or the panel judge can also impose certain conditions to the authorization. So that would be the procedure. And by a certain stage, there are also provisions under the law that they will have to go back to the panel judge for further authorization. As regards the case in the U.S. as to the composition of that court, I have no idea whatsoever. But then I believe that at least there will be one judge. Whether or not there might be more judges, I'm not sure. But then I suspect that there would be at least one judge chairing the hearing, and there will be authorization. But then in the case of Hong Kong, we do have this panel of judges, and all of them are serving judges. And they are also experienced in dealing with such cases, and therefore, when compared to the operation of a court, it's very similar. Well, for the details, I'll defer to Ms. Yip. Thank you, Chairman. I'm grateful to the Honourable Member for his comments. Well, both in the community and also with regard to the operation of the judiciary, we do have a lot of confidence in that. That's why when we enacted the legislation, we also obtained comments from members, and we also put in place a very stringent mechanism. In fact, under our mechanism, the court and also the judges will play a very important role. So for any LEAs, if they wanted to undertake any covert surveillance or intercept materials, they will have to approach a panel judge, and we have 3 panel judges, and they will have to come from the court of first instance, and we will have to have authorization from one of the panel judges. And in making the authorization, the judge will also have to consider whether or not the LEA is able to serve the purpose of preventing or detecting crimes to protect public safety. So the panel judge will have to see if there is this purpose, and also he will also have to make sure that the test of necessity and proportionality can be met, and therefore in terms of the authorization by the panel judge, that will be done. And as the Bureau Director just said, the Commissioner will also have to be a High Court judge, and he will also be working full-time to oversee the LEAs in undertaking such activities, and a detailed account will have to be given to the Commissioner, and every year there will be an annual report to be submitted by the Commissioner. We will also have to come to this Council to explain the details, and therefore both the court and the judges will be playing a very important role under the mechanism. Next, Ronnie Tong, and then Raymond Wong. Thank you, Chairman, for allowing me to speak. Chairman, I'm sure the Bureau Director understands very well that under Article 30 of the Basic Law, where Hong Kong people's communications rights are protected by the law. And as you might recall, our ICSO was forced into place, and the scope of the legislation is just to regulate the acts by the LEAs. In fact, this is also to legalize their acts, but then in the wake of the Snowden saga, it has also highlighted one problem. That is for the hacking of private individuals' activities, there is no law to regulate such activities. And last week, we asked a question and the administration came up with a response, and I think that's very misleading, because last week, in the response by the administration, the Bureau Director said that actually for non-LEAs undertaking hacking or covert surveillance, there would also be laws to protect them, and they propose Section 24 and 27 of the TO, the Telecommunications Ordinance. I'd like to point out to the Bureau Director that Section 24 would only apply to service providers, and then 27 would only apply for those who are interfering or who are intercepting such facilities. But then, other than that, there is no law whatsoever in place to protect the communications of private individuals here in Hong Kong. And under the basic law, the constitutional duty of the SAR government is not just to enact legislation to regulate such activities by law enforcement agencies. You should have extended the scope of the ICSO so that at least it should cover non-law enforcement agencies' interception or covert surveillance activities. Well, you might not think that it's necessary to criminalize such activities, but then for interception of communications and so on, well, for law enforcement agencies, if they undertake such hacking activities, we can assume, and the public would also agree, that the purpose is legitimate because they are there to prevent the committing of crimes. But then if you are not a law enforcement agency, and if you hack into or tap into communications of others, then the purpose would obviously be illegitimate. It cannot be legitimate, right? And given those circumstances, I'd like you to respond to 2 points. Number one, you will have to clarify that for the TO, you referred to that on Section 24 and 27 last week. In fact, it has nothing to do with what is happening. They are not able to protect Hong Kong people. And number two, the administration should consider amending the ICSO so that the scope would apply to activities undertaken by non-law enforcement agencies, so that hacking and also interception of communications would become criminal offenses. Yes, last Bureau Director, yes, I refer to 3 pieces of legislation. Number one, Section 24 and 27 of the TO, and number two, if such acts involve collection of personal data, then of course that would be subject to the PDSO, or the protection of personal data, or protection of personal data ordinance. And you also talk about hacking into telephone conversations and so on. I believe that such communications would be covered by that. But then on that occasion, I also made it clear in my main reply that concerning the regulation of NGOs and also on personal communications, the relevant policy bureaus in the SAR government will be considering whether or not, on the basis of the existing legal framework, there is a need for us to further enhance that. But then in the consideration process, we also have to take into account other policy considerations, including the upholding of press freedom. But let me also elaborate a bit on that. Chairman, is the Bureau Director saying that, well, for media people undertaking interception, then you would be prepared to allow that? Well, that would be highly unlikely, because in the UK, if you intercept into the royal family, then there would also be extensive condemnation. And even if the media hack into your telephone conversation or my telephone conversation, I would not have regarded it as legitimate or appropriate. No, I have no intention of saying that is appropriate or inappropriate. I have no intention to comment on that. But then all I'm pointing out is that press freedom is also a very important element in our consideration, and that's why in the process of our consideration, we will have to take that into account. Why have I said that? I was coming to that a moment ago. Well, earlier on, at the Constitutional and Mainland Affairs Bureau, they also consider the stalking report by the LRC, and the conclusion is that there are divergent views in the community with regard to press freedom and freedom of expression. The views were very divergent. So all I'm trying to point out is that this is a very complex issue. That's why the relevant bureaus in the administration will have to consider that very carefully on the basis of the existing mechanism.
One last point. For the ordinance we are discussing today is regulating the acts of LEAs. LEAs are allowed to do certain things and they are subject to monitoring. For non-LEAs, we have to look at them differently. And the ordinance was not enacted because of the non-LEAs. Mr. Wong Yuk-man, there are 4 areas to the review. I don't have strong views on them. We've been talking about the report of the ex-commissioner on numerous occasions. I remember in the previous term, the ex-commissioner's report mentioned all these problems. What is better late than never? As the Secretary said, it's a complex matter, but what's not complex is that the LEAs are breaking the regulation. For the 4 areas, for example, checking protected products by commissioner, power of panel judges and authorizing officers, and the construction of terms of relevant persons, duration, and the time gaps should be addressed, and any reporting of non-compliance to commissioner. I've talked about these previously. And now I asked to enhance the penalty to non-compliance acts of LEAs. For example, without authorization, tapping into communications. These are not about loopholes in the ordinance, but in some cases, LEAs are not happy to cooperate with the commissioner. You have to establish the reputation of the commissioner in the eye of the LEAs. Just Judge Wu was not happy about it. He could criticize as he liked, but the officers would not pay regard to him. For non-compliance officers, the penalty to them, their acts should be criminalized. The administration says that these officers can be prosecuted for misconduct in a public office. But how come you do not have special provision for that? It will be clearer in terms of law. Set down clear penalty. Criminalize some acts, some non-compliance acts, so that the LEAs will not be caught inadvertently because of misunderstanding of the law. So common law is not your trump card. Places where statutory law may have better provision for human rights, well, except for the mainland, but it's not our focus today. I think what you're doing is outdated. There should be specified provision in the ordinance to catch up with time. I think this is an important step. The first 2 items will attract discussions on Snowden. I expected that. But this case is not about, but we haven't been able to touch on the crux of the matter. Still, I want to raise a question. The administration tapped into our systems, and now the administration is tapped into by the U.S. government. Now, you said the TO Section 24, 27, and the Personal Data Ordinance are applicable to cases of interception, but that's not the case because they do not regulate the LEAs. This is the ICSO. It targets us, or it targets the LEAs. What about non-LEAs? They are not regulated under the ICSO. There is no review in this regard. What about foreign powers? They make use of advanced technology and tap into your system. What can you do to punish them? Just several seconds for the Secretary to make a reply. You can be flexible, Chairman. Secretary, please, a simple answer. All law enforcing officers understand the requirements of the ordinance and the consequences of breaking the law. In the light of suggestion of ex-commissioner, any LEAs who do not comply with the law, the views of the commissioner will be sought first before a decision is made. The ex-commissioner thinks this is appropriate, so we think it's fine. Misconduct in public office. CFA already set down clear guidelines in the common law, and there is also clear guidelines in the common law. And as reported, this offense has been triggered for prosecution, and the penalty is not low. The offenders will be may be sentenced to imprisonment up to 30 months. So the current penalty is sufficient, I think. And Chairman, I think this is outrageous, ridiculous. Under the common law, under misconduct of public office, this is just too wide. The requirement is too wide. But now the government saying the penalty is already very heavy. I'm asking for specific provision under the ordinance so that the LEAs will not be caught in the law inadvertently. All right for you, Mr. Wong and Mr. Porsche. I'll give more time to the Secretary to give a reply. I'm not going to ask similar question. It seems we're trying to regulate some small parties. But for parties with much power, we can't regulate them. This is exactly the point made by another member. Mr. Tong mentioned the basic law. On the face of it, we should not be targeting certain officials, certain law enforcement agencies. The ordinance is there to protect people's rights. This is abstract. Can we do that? After the Snowden incident, we understand that we may spend lots of effort, time in this discussion. It's like people are engaged in off-course betting. This is an analogy. I'm sure the commissioner would like to see review, and he wanted to see review over the years, but maybe we are only addressing the tip of an iceberg here. Mr. To asked about extraterrestrial rights. This is something very broad. We may not be able to address it today. But Secretary, apart from the proposed review for protection of privacy of Hong Kong people under BL, or to target what has happened, how can we do something about the current situation? Well, what if an ego is interfering with us? Or what can we do to ensure the protection to Hong Kong people's privacy? So I'll give some time to the Secretary for reply. Thank you, Chairman and Mr. Chair. I don't really know how to gamble on racing, just like you. So I'm a layman in this regard. But how can we protect computer safety? Technology is evolving every day. We have lots of experts in the administration, and we'll do our best. In the past few weeks, in LASHCO discussions, we mentioned that our experts working on administration system, the privacy, communications freedom of individuals and SME is also the responsibility of individual parties. So on the one hand, we have to look at prevention. The other hand, law enforcement. Sorry to interrupt, Secretary. We target LEAs. We regulate their acts. What about non-LEAs? What about people who resort to backdoor method, who are conducting these acts outside Hong Kong? We may not be able to control these acts. Whether CUHK system has been hacked into, I don't think there has been a clear answer to that. And the technology of interception is so advanced that we may not know where the system has been hacked into. So what are we supposed to do? As I said in my previous reply, today we are discussing the review of ICSO. Mr. She talked about non-LEAs who infringe privacy of other people and how we target these people. This is a separate matter. I think Mr. She is concerned about this part. And my reply is actually addressing the first part. We have to make sure our system is safe. We have to look at the technological advancement and what our experts can do. As you said, technology is advancing every day. Say, for example, vampire, the so-called vampire programs, something I've heard. We have to address that. Another issue we have to address is the legal aspect. Policy bureaus, relevant policy bureaus will see how we can address members' concern under current legal framework. This is a complicated matter, and it can't be answered in such a short time. As I understand, there will be another oral question tomorrow, and there will be another opportunity for me to address that tomorrow. Mr. Leung, 3 points, Chairman. When ICSO was enacted, no respect was shown to LEAs. We asked Judge Wu to do something, but he did not pay regard. He is a judge, but he's a judge appointed to the commission. We asked for a sunset clause, he refused. And 10 years down the road, from 2005, from that time, Donald Chang said his words are the laws, but in 2006, the administration lost in a court case. That's because he refused to listen to us. We can't compel you to make changes without the sunset clause. Misconduct in a public office cannot regulate the acts we talked about. If you make it a criminal offense, things would be resolved. LPP is absolutely confidential. I'm not talking about tapping into mobile phones, but tapping into the phone of a law firm. Many barristers are having phone conversations. Tapping into the conversations is a kind of punishment. If the information collected is regarded as intelligence, then it can be used to threaten other people. It can be passed on to some magazines. All right, second point. For non-public officer, they may be working in private companies. You cannot regulate their acts, and now you refuse to regulate them. Third point, this is more important.
If you try to go further to regulate non-law enforcement agencies, then inevitably you will be regulating overseas agencies conducting hacking and surveillance in Hong Kong, like public security officers. All right, if the U.S. hacks into our systems, then it's not allowed. Then how about public security officials? So you will be stuck. So my conclusion is very simple. Irrespective of who that guy may be, you will be regulating them anyway. And at present, for LEAs are not complying with the law, then you're actually criminalizing such acts. You'll be suing them. And also in Hong Kong, for non-Hong Kong or non-local LEAs, they will also have to be regulated. And also for overseas authorities, whether they are intelligence agencies or commercial entities, they should all be regulated. And if they have been caught, then you will have to prosecute them. And of course, if you're not able to catch them, then of course nothing can be done about it. I cannot ask you to arrest Barack Obama, but then if he's in Hong Kong, then of course you can catch him and arrest him. And yet if you do not even have the tool available, then even if you're able to arrest him, you will have to let him go. All right, do you understand that? So when can you come up with that legislation? Do you agree that we should regulate all, irrespective of who they are, and they will have to be sent to jail, and if they break the law, and if they are, well, for LEAs, they will have to, they will be subject to criminal sanction, and also for non-local law enforcement agencies, they will also have to be regulated. Do you agree? Bureau Director, there is one point that I have to clarify. Our law enforcement agencies will not and will never attempt to make use of any materials that they get hold of in the course of discharging their duties to threaten or to blackmail the persons involved. Well, how can you guarantee that the individuals will not be doing that? For the administration, you can make that guarantee, but then, or else, how come East Week has been able to disclose the acts of or the activities of Greedy Zhang? Well, I have to clarify that that would never happen. And also, under Section 31 of the ICSO, it also provides that LEAs will not be allowed to intercept into the communications or telecommunications of the residents and also the offices of any particular lawyer. And therefore, we do not believe that that has taken place. Mr. Leung, I cannot tolerate that. Mr. Justice Wu has already said that that is not tolerable, but then they have committed those acts anyway. All right, so much for the response. Well, as I said, Ms. To said that she would like to hold a public hearing, but then I'd just like to say this. That is, if you look at the report, basically it's about the authorization and is a proposal by the former commissioner about the authorization and how that should be made. It's not a comprehensive review of the legislation, and therefore it's not possible for us to open up the whole case for consulting the public. So my suggestion is, as we have done for the previous item. All right, we'll invite submissions from the interested parties. With regard to the issue about authorization, we can consult the public on their views, and then we'll decide if there is a need for us to hold any public hearing. All right. Now, on item 4, resources proposals relating to the upgrading of the Tseung Kwan O Police Division to a police district, creation of a permanent chief superintendent of police post, and the construction of Kowloon East Regional Headquarters and operational base, Ngau Tau Kok Divisional Police Station. To assist us in our deliberation, we have the Undersecretary for Security, Mr. John Lee, Mrs. Millie Ng, Principal Assistant Secretary for Security, Mr. David Cartwright, Regional Commander, Kowloon East, Mr. Abraham Cheng, Chief Superintendent of Police, Ms. Janet Ong, Superintendent of Police, Planning and Development Branch, Mr. Yu Wai Keung, Chief Project Manager, Architectural Services Department. Undersecretary, we are seriously overrun. I'm sure members have already read your paper, so can you be most brief and succinct in highlighting the salient points of the paper? All right, thank you, Chairman. Well, in January this year, we came to the security panel to brief members on the proposal to upgrade the Tseung Kwan O Police Division to a police district, and to time with the timetable for that upgrading. In terms of hardware and software, we will have to provide both resources, including the creation of a permanent chief superintendent of police, so that he can become the commander or the district commander for Tseung Kwan O. We also have to construct the Kowloon East Regional Headquarters in order to cater for that, and also to cater for the needs of the development of police work in that area. And before the upgrading of Tseung Kwan O Police Division to a police district, we will have to set up this permanent chief superintendent post, so as to put in place the arrangements and implementation plan for the upgrading of the Tseung Kwan O Police District. We will also have to contact the local representatives, and we will have to come up with a strategic plan in order to combat and detect crimes in the district more effectively. And also, in the foreseeable future, with rapid growth in population in Kowloon East, and also with the corresponding increase in demands for police work, we also have to build this operational base, Ngau Tau Kok Divisional Police Station, in order to enhance the efficiency and effectiveness of our work, in order to cater for some emergency needs. And with the construction of the new regional headquarters, that would be able to accommodate the Kowloon East regional headquarters, and also the traffic wings officers, so that upon the upgrading of the Tseung Kwan O division, we will be able to tie in with the upgrading of the Tseung Kwan O district, and we expect that we will be able to start the tendering exercise in March next year, and we expect that with the upgrading of the Tseung Kwan O Police Division to district, we've already consulted the relevant district council and obtained their support, and we are here to listen to your views. Thank you. All right, with regard to the issue involving the upgrading of the Tseung Kwan O Police Division to a district, we have already discussed that before, and we are here to give our views. And under Rule 83A of the Rules of Procedure, we'd like to remind members that if members have any direct or indirect pecuniary interest, then before you speak, please do declare such interests. Ms. Elizabeth Kwok. Thank you, Chairman. Of course, we are all for the upgrading of the Tseung Kwan O Police Division to a district, and we are also in favor of the funding proposal. I understand that the upgrading can only be completed in 2015. I'd like to know a bit more about this. That is, in the short term, will you be increasing manpower so that for the police presence in Tseung Kwan O, it can be enhanced in order to ensure that law and order can get better safeguarded in Tseung Kwan O? All right, 4 minutes each. Thank you, Chairman. Well, in fact, for the police works demands and also the additional manpower that will be needed, we've already done that in the past. Back in 1992, well, at that time, we only had about 180 officers. But then with the increase in population and also with the increase in demand for police presence, the number of staff has already increased to 219, and then in the second stage, 295. And latest, we have already increased that to 334. All in all, the population has already grown to 4.1 million. 410,000. So that would be covered in the Kowloon East region. And other than the 334 people, other officers in Kowloon East can also go to Tseung Kwan O to help out if there is a need. And therefore, in Kowloon East, we have 3,600 police officers in total. And where there is a need, we can always deploy officers from Kowloon East region to Tseung Kwan O to help out. Actually, looking at the related issues, whether it's Tseung Kwan O or Kowloon East region, at different times, they've also stepped up their police strategies. For example, they'll be targeting some of the crime black spots so that during night time and also during the early hours of the morning, Shift B and C's beat patrol has been stepped up. In particular, during the school hours and also when schools are off, there will also be step-up patrol. And also in terms of combating triad-related crimes, we have set up a hotline so that we will be able to receive intelligence or tip-off. And also in 2010, we've already set up this anti-triad intelligence unit. And also in 2012, we have also increased 20 special duty squads. So where there are emergency situations, then of course the emergency duty squads and also the and also the EU and the PTU would be involved in the special duty. And therefore, in looking at the needs in Tseung Kwan O, we have already put in place a package of measures to increase the replenishment of force for that district. Ms. Kwok? Yes, we understand that there are a number of measures. It shows the crime situation in Tseung Kwan O, and we do appreciate that. Still, some residents are of the view that in Tseung Kwan O right now, because Tseung Kwan O is a very strange community, because most of the time, most people would be walking around in the footbridges, in the shopping centers, and then in the streets there are dark corners. Yes, it's very much a downtown area. There are some dark corners and so on, and that's why many people are of the view that police presence is inadequate. That's why when they walk on the streets, they are still rather worried. So given the present police presence, they are not enough to assure the public. So can you consider increasing police presence? I understand that the present measures are already very good, but then please do consider further enhance them. Yes, Ms. Kwok, as you might recall, at the last meeting we talked a lot about that, so please focus on the proposal right now. So it's about the creation of the permanent chief superintendent post and also the construction of a new police station. Please focus on that. Mr. Gary Fan, Chairman, I have 3 questions. Number 1, well, actually the Sai Kung District Council and also local representatives are very supportive of the proposal to upgrade the Tseung Kwan O Police Division into a police district. That's why I support the overall direction of the paper. But then I have 3 questions. First, on paper number 6, that is the background paper by the Secretariat, is about the police presence. That because the ratio between police to the public is 1 to 1,600, but then if you look at the territory-wide situation is 1 to 250, and according to the estimate by the Bureau upon the upgrading, if you look at the police ratio is 1 to 600. In other words, territory-wide, if you look at the ratio, the range is very wide. So can we be told, in response to this growth in population and also because of the mix in industrial and residential buildings and also the crime trends and so on, so even after the upgrading, how are you going to respond to the query? 1 to 600, is that a reasonable ratio? Well, of course, in some areas, they will have a higher ratio, 1 to 250. But then when compared to those areas, the how does Tseung Kwan O compare to those areas? How can you reassure the public?
And in Kowloon East, the police station will be expanded. There will be a new police station. As I understand, the Kowloon East region officers, after they have moved out, do we have to expand the Tseung Kwan O police station? I understand on the OZP there will be a court, FSD facilities in that area. Will we still have the Teo King Ling police station, or is it not going to be built anymore? The first question, police strength, police manpower, has been discussed earlier on. So, Mr. Lee, over to you. In deciding how many officers should be present in a district, Mr. Fan got it right. Now, how do we determine the number? We look at the crime rates, the workload, the population of the area. We also have to look at the service needs and how many beats there should be. The mix of commercial and residential areas. So it's difficult to come up with a simple formula to calculate how many officers should be present in an area in a district. For the ratio, as mentioned, in terms of population, Tseung Kwan O is comparable to Wong Tai Sin. Wong Tai Sin 420,000, Tseung Kwan O 410,000. Wong Tai Sin ratio 1 to 600 and 1 to 400, and Tseung Kwan O 1 to 600 at present. Wong Tai Sin 1 to 400. We have different ratio because we have to consider a basket of factors. After Tseung Kwan O has been upgraded to a police district, what's the police manpower going to be? What's the ratio going to be? This is part of the duties of the CSP. He has to estimate the requirement, how many officers should be required in the district, and he has to make application for relevant resources for that. What about the police station? Tseung Kwan O police station. No plans for the Teo King Ling station at present. The one we're talking about is the headquarters for the Kowloon East region. That will cover CID, the EU, the traffic unit, the public relations, and SDS will be included in the headquarters. And the Ngau Tau Kok police station will also be relocated to the new headquarters. That's to cut cost. The headquarters is situated in a very good location, and that will enhance the service provided by Ngau Tau Kok police station. The regional officers will be stationed in the headquarters, and the service quality will be enhanced for the whole region. Mr. Tony Share. Mr. Paul Share. I go along with the upgrading because Tseung Kwan O has a large number of youth problems. Now, there are pros and cons to anything. So what are we to lose in the Kowloon East region? Which district loses police manpower when Tseung Kwan O is upgraded? We will increase resources to upgrade Tseung Kwan O to our police division. The officers serving Tseung Kwan O at present will be officers serving the new police division. we don't have any plans to move personnel from other districts to Tseung Kwan O district. For KE region, that is Kwun Tong, Sam Mo Ping, Wong Tai Sin, and Tseung Kwan O, including the railway unit, which serves a different public. During the building of the KE headquarters, the police force will consider whether we have to make amendments to demarcation. We'll also consider whether we have to make arrangements for deployment of resources at that stage. But at present, we don't have any plans to deploy other officers from other regions to Tseung Kwan O district. Our plan is to increase resources for Tseung Kwan O. For the creation of CSP, after our discussion, it will go to PWSC. It will go to EC, and as for the creation of the headquarters, it will go to the PWSC after our discussion. So, members, shall we endorse the proposal? If that's the case, we'll conclude the discussion of this item. And we'll move on to the last item. That is how police handling of cases in relation to public order events. We have only 7 minutes left. I can only extend the meeting for 15 minutes up to 4:45. Let's see if that's enough for our discussion of this item. If not, we'll make further arrangements. With us today are Undersecretary Mr. John Lee, PAS for Security Mrs. Millie Ng, Ms. Winnie Chiu, Assistant Commissioner of Police and Superintendent Licensing Mr. Thomas Wong. Paper is not very long. Undersecretary, briefing please. This is requested by the panel. This discussion is requested by the panel. As mentioned, on the 22nd of May this year, in answering questions from LASHCO, we already gave a reply on our handling of such cases. We already made available relevant information. I stress Hong Kong police is fair, impartial, and just in handling all public demonstrations and marches. Our objective is to strike a balance to enhance and facilitate all peaceful demonstrations on one hand, and to minimize impact on road users and other members of the public, and to safeguard the safety of such activities. The participants of such activities should be peaceful and orderly in voicing out their views. They should not break law and order or resort to any violence. If it happened, the police have to restore public order. According to internal guidelines of the police, if we're to make any prosecution to people arrested, the officer in charge will seek advice from DOJ. All prosecution decisions will be made by the DOJ after viewing and making reference of evidence available. Decisions are not made under any political or other influence. Hong Kong is a city of rule of law. Police act in accordance with law. We do not consider any political influence. Anyone breaking the law will be dealt with by the police in a fair and just manner. There will not be any different treatment to people from different backgrounds. Mr. Lee Chak-yen, Dennis Kwok, and Mr. Chen Kam-lam. All right, 4 minutes each. Let's get cracking. Andy Chung just said some rubbish. Yesterday, at the demonstration, people asked the police to open up the eastbound lane outside Sogo department store so that demonstrators can join the queue in a smooth manner to go to Central. The police said it's a decision made at spot, but because of that, people are trapped in Causeway Bay. How come they did not make prior arrangement to open all 6 lanes? Andy Chung just talked some rubbish. It's best to give prior notification so that the demonstration, the march can be facilitated. People can reach the end point earlier. Well, yesterday, it shows Hong Kong people were very orderly. Under pouring rain, people were orderly when they are trapped and stranded in Causeway Bay. I think the police creates a trouble for us. In fact, the demonstration could have been conducted in a more smooth manner. From the 2nd to 9th of June, there were 4 assault cases, one of which involved a folding chair. The incidents are related to one group, a youth group, and they were not happy with the Falun Gong supporters, and some people were assaulted. However, the victim usually is taken to the police station and accused and charged for fighting. The one whose had got injured was not accused only. He was not the one. He was the one who's not accused only. The police were there at the scene and saw that the victim was assaulted. Undersecretary, Chairman, I'll take the second question first about the pedestrianised area in Mong Kok. Our established practice is to respond to complaints or any inquiries for assistance. This is a long-established practice and will act in accordance with the system. We have to target the problems in different areas, and we have to make arrangements for police manpower to respond to the cases. For individual cases, I've heard Mr. Lee's views, but the police is just and fair in handling the cases, and they act in accordance with the law and responded to the situation at a time. We have to focus on the case and people involved. For the march yesterday, in discussing the route and before the letter of no objection was issued, the organizer and the police held numerous meetings, and we also conducted site visits. According to the agreement and the letter of no objection, the eastbound lane is for emergency vehicle access, and it's not part of the agreed route. That's why the police responded as they did. Mr. Dennis Kwok and then Mr. Chen Kam Lam. Para 6 of the paper talks about an internal guidelines, which is about prosecution. So, if a demonstrator breaks the law, will the police seek legal advice from DOJ as soon as possible? After the legal advice is received, will there be any time limit on when the person should be taken to court and be prosecuted? Now, someone is suspected of breaking the law 2 years ago. It's only after 2 years that the police arrested this person. This is unreasonable. It's confusing. In that case, the DOJ said legal advice was given to the police way earlier than that. It's just that the police refused to act, or they did not act. So what's the police to do? Are there any rules about prosecution, time limit? Thank you, Mr. Kwok. The police would like to deal with the cases as soon as possible. There's no doubt about it. In terms of serving the public and resource management, we have our principles. As to the time limit, the nature of cases differ. In public events, witness, visual clips, pictures are involved, and sometimes you may not be able to identify persons you want. So sometimes it can be difficult, and individual cases differ, but our principle is to deal with cases as soon as possible. The case mentioned by Mr. Kwok, for that, the police tried very hard to identify the person, to locate the person involved. DOJ gave legal advice, but the police had to arrest 9 people in that incident, and we adopt the same treatment to the 9 people. 7 out of them, having been notified by the police, contacted the police, and they have been dealt with accordingly. For 2 of them,
when the police tried to approach them, they did not cooperate, and one of them was not the person referred to by Mr. Kwok. In fact, he or she was only prosecuted after 4 months since the police started to contact him or her, and the police also adopted the same measures. For example, for all the known addresses of the person, the police tried to locate him or her, and they tried to wait for him or her at the locations, and the police also tried to contact him or her on various locations by phone, and there was no delay whatsoever by the police, and irrespective of the background of the person involved, the police adopted the same approach. Mr. Kwok, well, we will have to hand over the floor or the room to another meeting before 5:45, and a few other members would like to speak, James To, Kwok-him, and so on. So can I deal with it that way? I would also very much like to allow you to speak whatever you want, and everyone will be given 2 minutes, and then we can have a consolidated reply. If we are not able to deal with all the issues, then we will have to defer the meeting or the discussion item until the next meeting. Yes, I'll give the floor to another member. Yes, Chen Kam-lam. Chairman, well, for Hong Kong people's freedom of speech and assembly, well, those are the freedoms enshrined in a basic law. And of course, for such freedoms, when you try to exercise them, you will also have to make sure that it's allowable under the law, and that would also not affect the legitimate rights and interests of the other members of the community, and that also should not affect the peace and order of the locality. And also with regard to the number of people taking part in any public meetings, that's also an important consideration, because the police will also have to put in place their planning arrangement, and also that is to ensure the safety of the public meetings and so on. I'd like to cite some examples, because in the past, after a public demonstration, the police estimate and also the organizers' estimate would be very different. And even a third party, for example, some academic institutions, their estimates would also be very different from the estimates of the organizer and also the police, where there is such huge discrepancy between the different estimates, how would the police make plans for that? For example, taking yesterday as an example, according to the police, some 60,000 people took part, but then according to the organizer, 430,000, but then according to the institutions, up to 90 or 100,000 people took part. All right, if there were 430,000 people, then of course the police arrangements would be a lot different. And of course, in terms of the risk factor, it would be a lot higher. But then in reality, what is going to happen? So will the police or the administration come up with a more comprehensive assessment or forecast in the future? Mr. Paul Chair, I'm also interested in that because given the huge discrepancy between the different estimates, will the police be psychologically prepared for what is going to happen so that more planning will be put in place? But I'd also like to follow up on a point made by Mr. Kwok. It's about the person being arrested and also the case in question. Because the arrest operation was delayed to a certain extent, there were criticisms that because the person involved took part in the planning for the Occupy Central, that's why you're trying to settle the scores after the event. So there is such an allegation. So without affecting this, the case details because it's sub judice, but then will you be disclosing more details, for example, for the individual working at a law firm or for the individual working at a media organization, if you try to make an arrest or if you try to make inquiries with the persons, there might be some difficulties. And of course, you do have some internal guidelines. You will also have to consider the nature of the offense. Can you afford to wait and so on? So I'd like to know more about these. Instead of having people second-guessing what you have in mind, can you disclose the procedures of the arrest? How come there has been such an extended delay? Mr. Kwok-him, and of course the police would conduct risk assessment with 430,000 people. Then about 15,000 police officers will have to be deployed. You do not have that many people. That's why you will have to suppress the figures. So that's understandable. I think a very good point has been made. Indeed, if you have so many people, definitely they will play it down because they don't have that many people to maintain the law and order situation. All right, I've been told that it's okay. And also, on a wanted person, I think it's a waste of time. How come you've been so quick in arresting me? How come every time when you arrested me, you'd been so expeditious? So did you take more than a day when you tried to arrest me? All right, they always came to my place to arrest me. All right, for that lady, when she went to work, she also had a home, unless she's invisible. All right, and also she actually interviewed C.Y. Leung. All right, you can match the name. So how could she have escaped and you just let it go? All right, it's okay. But then subsequently you decided to arrest her because she was involved in the Occupy Central campaign. All right, you've already laid charges. In fact, for public interest, you should. I think it's right for you not to prosecute. I think it's wrong for you to subsequently decide to prosecute because once she became the secretary of Occupy Central, all right, this is a young girl. Well, all right, she's so arrogant, and that's why you decided to arrest her. So it's okay. It's understandable. But then, all right, I have decided not to arrest you, and yet you try to be involved in Occupy Central. That's why I have to arrest you. You're just preventing her from committing further offenses, right, James TO? Well, in yesterday's march, well, because according to the Democratic Front, they said that there were certain agreements because when it's too crowded, you would be opening up the eastbound lane in front of Sogo. Well, the CP came out to deny it, and if the CP did not look into the details and if he just denied it anyway, then it would be like what had happened beforehand. So it's like you're just making a joke of yourself. all right, you should have checked the records and you should have issued the memorandum of understanding to the other party. And if they do not agree, then at least you can clarify whether or not it had been the case. In the case of Melody Chen, all right, you said that you had spent a lot of time to locate the person. All right, if the CID spent more than a year to locate a person and failed, then it's really quite a joke or quite a laughing stock, because for those wearing the mask for Vendetta, V for Vendetta, actually you were able to locate them very easily. And yesterday I saw this phone-in program, radio phone-in program host. Her name is Li Wailing, and she just tried to confront you, and she tried to argue with you. And what's the point of taking her away? All right, for journalists, they were carried away. And then for this program host, she's just reflecting the views of the public to you, because old men and children were braving the rain and the inclement weather. How come you're carrying her away, even though she's not posing any threat to public safety? All right, I'll just give you 3 minutes. Please be brief in your response, and if needs be, we can always include that in our agenda for our next meeting. On our estimate on the number of participants in any public meeting, well, that's only for internal reference in planning for police presence and how much manpower do we need and where should we be placing our police resources. That's for internal reference. But then very often, because the media are very interested in this figure, that's why we also disclose that to the public and the media. So you said that in terms of the figures, well, what our considerations are, that's just on practical needs. There is no political consideration as to the discrepancy between our estimate and the media or the organizers' estimate. I'm not going to comment on that. But then there are some impartial and independent parties, for example, academics from universities. They've also made some estimates, even if the numbers might not be entirely the same as that from the police, but then the discrepancy is somewhat narrower. So that's for all of us to judge. And it's also mentioned that in arresting an individual, it has taken us an excessively long time, as the case will be tried in court tomorrow. It's not for me to comment on it. But then in the case, the actions taken by the police have never been affected by any political considerations, as I've already said in reporting the details of the case as to how many phone calls we have made with that person, and for the various locations that we have been to locate that individual. I hope that you understand that the police have never relaxed its efforts in locating that individual. And also for another suspect that we also try to arrest him or her, we were also not able to locate him or her. Only after 4 months, when he came to the police station, were we able to arrest him. In fact, in trying to put a person on the wanted list, all right, the actions taken by the police will have to be proportionate to the actions or the offenses committed by that person. That's why Mr. James TO was right in his arguments. That is for the police officers in charge of a case. In considering the way to arrest a person, he will have to consider different approaches. For example, should only the team members be aware of that? Sometimes it's important, because we may not want to arrest that many people, and therefore the suspect would only be made known to the investigating team. So that's one approach. And if it's felt that in arresting that person, all right, the timing is not that critical, so long as we can locate him is okay, then we would also be putting that information in the computer system, so that for every police officer in contact with him, he or she would know that this person is on the wanted list. All right, time's up. So we will have to move on to the last item, and we'll consider if this will be included in the agenda for the next meeting.